My name's Lewis O'Brien. I've created this 5-minute guide series to property development contracts to help those who want to develop property, be it a small renovation or a large unit development, to avoid common mistakes and do it better. I believe that the ideas we'll offer you here will help you avoid a nasty car crash and help you maximize the profits from your next development. In this video, we're going to explore the laws around permits, insurances, and other restrictions that apply when you're renovating a property to sell. We're going to talk about when you need a building permit, when you might be an owner-builder and require the associated owner-builder inspection reports and insurances, and also when you might need builder's warranty insurance. These are complex issues, and obviously the laws vary between states. So what we're going to provide here is a quick overview to try and help you understand how the system works, and obviously the provisions we're talking about are relevant to the state of Victoria. The provisions in other states will necessarily be slightly different. In every case, you should be seeking specific legal advice if you have any doubt about your legal position rather than relying on this summary. The consequences of not getting a required permit can be quite nasty and are best avoided. The first thing to know about renovation work in Victoria is that a building permit is required for all building work. More specifically, Section 16(1) of the Building Act provides that a person must not carry out any building work unless a building permit in respect of that work has been issued. Put another way, you need a building permit for all building work in Victoria unless one of the exemptions in the regulations apply. Fortunately for renovators, there is an exemption that covers the repair, renewal, or maintenance of a part of an existing building, provided certain conditions are met. These conditions include not adversely affecting structural soundness, increasing or decreasing floor area, affecting the underpinning or footings, removal or alteration of any support element, and provided that it's done with commonly used materials and won't adversely affect safety. There are also a range of other exemptions that may apply in specific circumstances. Anyone that's thinking they're home free because they don't need a building permit is unfortunately sadly mistaken, because there's a series of restrictions on the activities or perhaps the regulation of activities of owner-builders that need to be thought through. Section 25B of the Building Act provides that an owner of land or a building must not carry out domestic building work as builder on that land if the cost of the work is more than $16,000. Well, that's the simplified version anyway. However, it doesn't end there. It's important to understand that this provision relates to domestic building work. So there are certain things that are excluded from domestic building work. These exclusions extend to electrical work, glazing, installing floor coverings, insulating, painting, plastering, plumbing, tiling, and some other minor works, provided that, and it's very much subject to the condition that those works are carried out by a tradesman under a contract for only that type of work. I guess if we're simplifying all this back, it means that you as owner-builder can do $16,000 worth of work, but we're excluding from that calculation the work done by licensed tradesmen. From another perspective, if you manage how you allocate your funds correctly, you could potentially do a $50,000 renovation by subcontracting large parts of the work out to tradesmen and still not be required to be registered as an owner-builder. On the other hand, if you don't manage it so well, you could spend $25,000 and find that you are an owner-builder if you haven't managed how you allocate the work correctly. Bear in mind that any subcontracts for more than $10,000 are also likely to be regulated by the Domestic Building Contracts Act in their own right. For those renovators that do fall within the definition of an owner-builder, there are essentially two consequences. The first is that you are supposed to get a certificate of consent from the Victorian Building Authority before you commence work. The second consequence is that if you sell the property within 7 years of completion, you're expected to obtain and provide to the purchaser an owner-builder inspection report and also owner-builder warranty insurance. These are not insurmountable problems, but you're far better to be prepared and not scrambling in the week before settlement to try and fix these problems with the threat of a purchaser terminating the contract hanging over your head. Where you sell a property and building work has been done, or domestic building work to a value of more than $16,000 has been done by a registered tradesman or builder, you're required to provide evidence of builder's warranty insurance. The Victorian government has helpfully renamed builder's warranty insurance as domestic building insurance to promote understanding. Gee, thanks for that. It is important, however, to understand the limitations of this insurance. It is valid for a period of up to 7 years, but only applies in the case where the builder is deceased, insolvent, or is otherwise unable to be found. It's also worth bearing in mind that in Victoria, no builder is liable for their building work after 10 years. To round out this video, I wanted to make the obvious point that, firstly, these provisions are quite complex. Unfortunately, there are different definitions, different inclusions and exclusions, and different terminology. However, none of that provides any legitimate legal excuse for not complying with the law. The second and emerging issue is that I think most lawyers and purchasers are increasingly aware of these provisions, and the internet provides great evidence of the work you've done. If you've bought a property to renovate and sell, the before pictures are probably immediately available to the whole world on the internet, which then provides a fair idea of how much work has in fact been done. The idea in the old days of what nobody knows is nobody's business really doesn't apply. So the old adage of she'll be right may result in your purchaser electing to terminate the contract of sale. At Lewis O'Brien and Associates, our goal is to make your next development more profitable. We can do this by speeding up the process, by avoiding unnecessary mistakes, and identifying opportunities for incremental gains. I hope you found this video informative and helpful. If you have, please feel free to share it with a friend. Make sure that you don't miss future videos by liking this video and subscribing to our channel, or alternatively, feel free to visit our website at lewisobrien.com.au and subscribe to our newsletter. Thank you for your time, and I hope to speak to you soon.